Hello everyone. Priyanshu, Priyanshu,
Hello, hello, hello. हाँ जी.
please start the session.
Okay, okay. Good morning to all the attendants and ma'am. I am Pranjit Sarwat and I will be hosting today. The goal of the day is to learn more about the law. May I start? Hello.
Hello, Priyanshu. Your voice is not properly. Right.
Hello. Is my voice up?
Yes, yes, yes. You can continue.
Hello.
Hello, you. Hello,
Yes, sir.
प्रियांशु. आप
Yes,
कंटिन्यू
sir.
करिए, आपकी वॉइस आ रही है हमें.
Okay, ma'am. Okay, sir.
एंड प्लीज एवरीवन अपना अपना माइक म्यूट करके रखिए प्लीज.
Uh, I am Pranjit Sarwat and I will be hosting today. The goal of the day is to learn more about the law pertaining to testimony succession, also known as will, as discussed by our eminent guest, Advocate Aishwarya S. Hanchet, who practiced before Karnataka High Court and has represented has represented numerous clients in case pertaining to agenda area. At the conclusion of the session, any queries and uncertainties will be answered. I now invite our speaker, Advocate Aishwarya, to take the stage to address the agenda of the day.
Thank you, Akshay. Thank you, everybody. Thank you for inviting me for this webinar. And it's indeed an opportunity not just to engage with you on this topic, but also I had a selfish motive, in fact, to say yes to engage with the webinar. Most importantly, that before even I say something about this topic, which I've chosen to, I should actually get to know a lot of things and I have to prepare. So it's just a selfish motive to learn more on this topic by myself before delivering any such talk or to talk anything about this topic. So the topic for today is law relating to testamentary succession. That's will. So I will be engaging this webinar for maybe 30 to 35 minutes. And in between, if you have any doubts, you may kindly raise your hand, or you can, post your questions in the box so that I can have the question there itself. Suppose if it has to be answered then and there, I will try my best to answer your questions. If I, if myself I am in a doubt, I am apologies, I will answer to you once I am clarified with the doubt. So any doubts, kindly raise your hands or you may post your doubts in the inbox. Okay, so let me now start with the topic for the today. What is the testamentary succession, specifically wills? So what does a document be distinguished between a will? Is will, if I write a will on a piece of paper, will it amount to a transfer? Or who is this person, who is this person who can come forward to make a will? Can anybody make a will? Can a 2-year kid or a 15-year-old boy make a will? Or can a age-old person who is maybe at about 80 years old, who is lying on the deathbed, can make a will? And the next question is, suppose if any of your family member who is engaged in a warfare, who is in the process of handling the crisis between two nations internationally, can that person make a will? Can be what institutes, what makes it a will, a valid will? Okay, when does this will come into effect? Once, if it has to come into effect, what has to be the conditions to be followed to validate the will? How the will has to be proven? All that will be the basic questions which I will be dealing with today. So what happens in this day-to-day life? You're in a constant struggle, in a struggle to either uh, expand your territory in terms of your movable, immovable properties. You want to make your life secured, you want to make your family's life secured, your children's interest to comes into picture. All of you is this the entire journey of your life from your birth to the death is nothing but a struggle to expand your territory in order to make your life a meaningful life, to settle down peacefully. So over the period of the struggle, you tend to acquire a lot of immovable properties, you tend to acquire a lot of movable properties. During the process, you give, you sell, disputes arises, and then you come to a stage wherein you feel like, what do I do with my properties? Do I just keep it like that, or do I actually make sure how the properties have to be distributed? Over a period of thought, when you just think, you come to a position where you will be like, what do I do with my properties? How do I give it to my daughters? How do I give it to my son and a daughter? How do I distribute it? Okay, should I just confine my properties to give it only to my daughter and son, or shall I just give it to somebody else who has taken care of me? Or is it compulsory that I'm supposed to give only to my children? Is it compulsory only that, okay, my children have not taken care of me, I will give the entire property to somebody else? Yes, whatever, it's your property, you can do whatever you want. So that's when this will come into picture. But sometimes what happens is, during the struggle, you will not make any such declaration. So what happens in that course of time, your interstate succession comes into picture. What exactly is interstate succession? See, laws like Hindu Succession Act deals with those property upon like how the legal heirs have to how the property devolves upon the legal heirs when there is no such explicit declaration made from your part. Like, you have this class 1 legal heirs, class 2 legal heirs, how the property has to get, first it has to go to your mother, children, then brother, then sister. There's this certain categories which has been referred in class 1 and class 2 legal heirs of your, for example, the Hindu Succession Act. But when it comes to a document such as will, it's called as testamentary succession. You write, you declare, your intention is put upon your papers to tell, how am I going to distribute my property within my legal heirs, or outside my outside the purview of my family. So that's the intention where this person expressly put upon his words on the paper. Then that document and that devolution of property henceforth will be called as intestamentary succession. Now that I've spoken explicitly about that there are these two ways of succession, interstate succession, testamentary succession, without law, there's nothing. So what is that law which deals about these testamentary succession? Now that I've been telling you that will, what is the will and everything, where exactly is this will actually defined? It's defined in the Indian Succession Act 1925. So now that there is such a law called the Indian Succession Act 1925, which is the main law in India, which governs the wills made by persons other than Muslims. So if the persons belong to particular community, that is the Muslims, the wills has to be proved according to the Mohammedan law. But when the will is made by persons other than Muslims, then the Indian Succession Act comes into picture. So, part 6, chapter 1 to 23 of Indian Succession Act deals with the law relating to wills. Now, there is Section 57, which of the Indian Succession Act, which talks about it is under Chapter 1, Introductory, application of certain provisions of part to a class of wills made by Hindus, etc. So it is nothing but the applicability clause as to who. My voice is not audible properly. Is it okay for everybody? Is it breaking? Because I got a message that it's breaking.
It's okay.
It's
Yeah.
okay, ma'am.
Okay, ma'am.
Thank you.
It's
Thank you
okay.
so much.
No, okay.
Yeah. So section 57 and 58 talks about the applicability of this law. So what does section 57 says? Application of certain provisions of part to class of wills made by Hindus, etc. So the provisions of this part, which are set out in Schedule 3, shall, subject to the restrictions and modifications specified therein, apply to all wills and codicils made by any Hindu, Buddhist, Sikh, or Jain. And they've given the specified date also on or after the first day of September 1870. So section 57 and 58 deals about the applicability, and section 58 clearly provides that these provisions shall not apply to the testamentary succession to the property of any Mohammedan. So the wills under which is also called hiba is being dealt under the Mohammedan law, and the wills made by Hindus, Buddhists, Sikhs are all dealt under the Indian Succession Act. Now that I've been talking about applicability, testamentary succession, interstate succession, what exactly is a will? What amounts to a will? How do you define a particular document to be a will? What are the essential, what are the valid essentials of a will? They're all defined under Section 2 Clause H of the Indian Succession Act. If you're all, I've been told from the organizer that mainly they are students from first and second semester, so I will make sure that I won't make this webinar too complicated for you to understand and go beyond your understanding. I'll make it as simple as possible. So there is this section 2 clause H which defines will. So what does it say? Will means the legal declaration of the intention of the testator with respect to his property which he desires to be carried into effect after his death. It sounds so simple if you read. It is like, okay, there are like two lines. What is it? It's a legal declaration. The testator should have an intention with respect to his property which desires to be carried into effect after his death. No, if you break up this section, there are three important conditions which has to be fulfilled to make a document to be called as a will. So let me break down to you. Firstly, that see, section 2H means the legal declaration. What do you mean by legal declaration? What declaration makes it legal? How is it that it is called as legal declaration of the intention? It goes beyond ahead. So legal declaration is nothing but it should, whatever you're making, whatever you're writing down on the piece of paper which you call to be a will, which you intend to be given to the effect after your death, should be in conformity with law. And the person who's making that will should be competent enough to make it. Firstly, I told that it should be in conformity with the law. What do you mean by conformity of law? Conformity with law. Let's say, suppose I write on a piece of paper that some XYZ person who is such and such person has to break open the locks of the doors of my neighbor and steal all the gold and realize the amount by pledging it and make his life comfortable. If I make such declaration in my will it be valid? Definitely not. It should not be against any public policy. So something which it should be within the vicinity of the law. Whatever the will, the wishes, the intention which you're intending to be should be within the vicinity of the law, which should be conformed with the public policy. Therefore, legal declaration is nothing but the something which you're making should be in conformity with law. And the person who is making that declaration should be competent to make it. as I was saying, can a 5-year-old kid, or let's say suppose a teenager who's 13-year-old kid, nowadays in this day-to-day affairs, you see that 12 years, 13 years, 15 years are way more mature than way back when we were 12, 13-year-old. So just because when the day is evolving like that, when a kid who is of 13 or 15-year-old, when he makes some declaration of paper, can that be made valid? No. A person should be competent to make it. Under Indian Contract Act, a minor's contract is not valid. The same thing. Who is that person who is termed to be a minor or major? So the Indian Majority Act says that any person who is of the age 18 year and above is known to be as the major. So any person who is above 18 years old can is deemed to who's the major, and he can make the will. Now let's say, suppose I am not in a fit state of mind, or maybe I am this person who I tend to forget, or maybe I'm this person whom I don't remember what's happening in and around me. So can that person be competent enough to make such declaration in a paper and be deemed it as a will? No, you can't. So there is this law which I will be further telling you who are those persons who are competent to make law. Now, next, second essential condition to make it a valid will is that it should relate to the property of the maker. Let me give you an example. I say that there is this one big hotel. I keep on going to that hotel. I love that hotel. So after my death, that hotel, I am giving it over to my children. Let the children enjoy all those properties. What I will make a declaration in that paper. Will that be valid? Definitely not. So I am competent to make the will only with respect to those property which I am the owner. Only when I own, only when the title possesses on me, only when I have title on that particular land, I can make the will. I just like that cannot say that such and such property which I used to see from over a period of 20 or 30 years, or my neighbor's property, I just like that cannot give it to my children. So that is the second main important property. Now another important thing which is being discussed is something called, you have something called as joint family property or ancestral property. So by birth you are co-partner. So because you are a co-partner to that particular ancestral property, can you give away that property by making a will to somebody else or to the beneficiary, whomever you want to? No. So a Hindu by way of his will can bequeath all his property, a Hindu. However, a member of an undivided family cannot bequeath his co-partnership interest in the family property. So it is very clear that if there is an ancestral property and you are a co-partner to it, you cannot make a will with respect to that co-partnership property. Now next, third important factor which or characteristic to make a valid will is it is to take effect after the death of the maker. So this is very, very important. So that's something which distinguishes from the other papers or other documents and the will is this point that the will come into effect only after your death. During the lifetime of you cannot bring that will into effect, which means to say you cannot bring into effect whatever clauses you have written into that, whatever you written into that property. So only when you write it, you intend to give, you intend to distribute such and such property to such and such people, that's only when you can actually, and that comes into effect only after the death of that person who's making the will. So this is the very important uh, in fact very important point which has to be kept in mind in order to classify whether that document is a will or not. Now you make a will, you make first will when you are what, 35. Then over a period of time you have acquired certain other properties, or you've sold
91 members.
properties. So what
91.
happens at that time is you can um you can revoke the previous will, or you can just keep that will without destroying. You can make that will at the age of 45. Again, now you reach at the age of 65. Can you make another will considering the fact that you've already made two other wills? Yes, you can make. So until the death of the maker, until the death of the person, you can uh, you can revoke the previous will and you can make another will. So the will which is lastly written will come into effect after the death. So any number of times the person can make a will during his lifetime. Um, now that I've said that the valid conditions of a will, now the Indian Succession Act also lays down two kinds of will. First, the privileged will. Second, unprivileged will. Section 65, 66, and 72 deals with privileged will. Section 63, 64, 70, and 73 deals with unprivileged will. Now that I've said you what are the sections which deal with privileged will, unprivileged will, now you should definitely get a question. What differentiates between this privileged will and unprivileged will? What makes a will privileged will? What makes a will unprivileged will? So these are all clearly mentioned under the Indian Succession Act. Now, in the beginning of the webinar, I had just given you a gist. Can a person who is engaging in the warfare, in the war field, or a person who is a mariner, can he make a will? Yes, he can make a will. And also section 65 also sets down who can make a privileged will. So a will is said to be a privileged will when the testator is firstly any soldier, being employed in an expedition or engaged in actual warfare. Secondly, an airman, so employed or engaged. Thirdly, a mariner being at sea. So these three category of persons can execute a privileged will. But these three persons has to complete their age of 18 years. So a person who is a soldier, who is an airman, or who is a mariner, who has completed his 18 years of age can make a privileged will. But how do you differentiate what does that will make it as a privilege? Just because the soldier, the airman, mariner makes it a will, that becomes a privilege will? No. But what differentiates that privilege will when it comes to an execution? So what happens in a privileged will is, in a privileged will, you write down the entire will. There is You need not attest that will. That comes under privileged will. But what happens in an unprivileged will? The will has to get attested. But in a privileged will, if that person, these three category persons make that will, it writes down that entire clauses of the will. He need not attest that will. Secondly, when uh, you can you can actually dictate these terms to the other person, who in your presence you can dictate to the person, that person may write down that will. That also can be said to be as a privileged will. And the clause B also, section 66 talks about mode of making and rules of executing privileged will. This is what I was talking about. The execution of privileged will shall be governed by the following rules. So there are rules which are set down. Firstly, the will may be written wholly by the testator with his own hand. So in such case, it need not be signed or attested. This is what I was been telling you. If that person who is a soldier or a mariner writes the entire will, it need not be signed or attested. Second, it may be written wholly or in part by another person and signed by the testator. So what happens? I tell my other colleague who's also equally part, or any other person who is in that service, I tell him that such and such should be the clause. You please write it down on behalf of me. Then such document, that person can write it and I will sign that document. And even that document need not be attested. But what makes it an unprivileged will? Can this also be done in term when it comes to an unprivileged will? Like suppose a layman like me, being an advocate or any doctor or a chartered accountant makes it a will, and if it doesn't sign it or if it doesn't get it attested, can the document be made it as a valid will? No, it is not. That is where this comes to a distinction that it is a privileged will and in an unprivileged will. So can this now that I have said you what exactly amounts to a will, the valid essentials of will, and now I came down to differentiating between that there are types of will, that is an unprivileged will and privileged will. But will this will amount to a transfer? Is there any is there any distinction between a transfer and making a will? Will this will after I write down, will this amount to a transfer of that particular property which you intend to give away? No, there is a distinction between a transfer and you making it a will. So in a transfer, what happens? In a transfer, the existing property is you are transferring the existing property to another person, a living person like I am giving my property to another living person. Maybe let's say I am giving it to my sister, or I'm giving it to my another person who's giving for a consideration, anything for that matter. So a transfer is nothing but a conveyance of a property from one living person to another living person. So the essential characteristics for a transfer is from one living person to another living person. But what did I say when it comes to will? Will the conditions of the transfer or the intention of the party giving away the property will be written on the paper, but that comes into effect only after the death of the person. So can will be a transfer? No, because in order to consider yourself to make it a transfer, the conveyance should happen from one living person to another. So this is one very important distinction when it comes to the difference between the transfer and a will. So what are the deeds which come under the transfer? The Transfer of Property Act says that there is sale, or be it gift, or be it lease, all these amounts to transfer. So as I said, transfer is nothing but the conveyance of the properties. See, like let's say sale. So I have a particular piece of land, a property which amounts to XYZ measurement in such and such place. I am giving that particular property, let's take to a very minimal amount. I'm giving it for 1 lakh to some B person because I am in need of money. I have my land, but I need money. So what I do is I give all my title, possession, and everything of that particular property to B person, and in turn, I'm getting in return of some consideration. So that is transfer. I am alive, that person is alive, so transfer is happening. So this is the very important distinction between the transfer and will. Second very important distinction between a transfer and will is transfer is irrevocable and it comes into effect immediately. Irrevocable in the sense, I have given my property to, let's take B person, and B person has given me 1 lakh to me. I have given all my title in favor of him. He is now enjoying the property. He has taken the possession. He is in fact he might do anything with respect to that property. But now that after like 2-3 months, can I say no, 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 I need that property, I am revoking that sale date? I do not have that power. Once a sale is made, it is irrevocable. I cannot cancel it. Once the sale is done, it's done. But what happens to a will? As I said, during that lifetime, at the age of 35, I make a will. Again, at the age of 65, I make another will. At the age, I feel like I do not want to give away any of my properties by way of will. I've done something wrong. I've burnt it, or I have torn that paper. So that will can be revocable. But whereas when it comes to the transfer, it cannot be it cannot be revoked. And third most important difference is in a transfer, your your effect is coming immediately. Let's take you're gifting certain properties. A father is gifting a property to his daughter. Then the transfer becomes immediately after going and registering before the sub registrar's office. But what happens when it comes to will? That will that will comes into effect only after the death. Somebody is asking the gift deed versus will. As I said, gift deed comes within the provisions of transfer. So whatever distinctions I've made between the transfer and the will applies to gift deed as well. So in a gift deed, a father is giving a particular property to his daughter out of love and affection. That is nothing but an immediate transfer. I can immediately take, I become the absolute owner of that particular property immediately after that document becomes registered. But what happens to a will? I cannot. If my father has made a will, I cannot immediately take over the position or the title in my name. It comes into effect only after the death of that person. So that is the three main difference between the transfer and the will. Now, let me come to this another question which you might be pondering upon. Who all can make a will? Can everybody and anyone can make a will? As I said before, 15-year-old, 2-year-old cannot make a will. Only a competent person can make a will. So to answer this, section 59 of the act talks about persons capable of making wills. I'll read out. Every person of sound mind, not being a minor, may dispose of his property by will. So there are two important. Every person of sound mind. So a person making a will should be of sound mind, and he should not be a minor. So what if I give this situation wherein I don't remember for 3-4 hours, ಆಮೇಲೆ after then after some interval I am all stable. So when I am stable, I write down these are my properties I am giving to such and such and such and such and person. So a person who is at interval times, who is of sound mind, that will also is valid when he is executed, when he is of sound mind, when he has the state of mind in a stable set. As I said, a major is a person who has turned 18 years of age under the Indian Majority Act. And also, another point to be noted in order to distinguish whether a person is sound mind or not is whatever you're dealing with the property, you should know with what property are you giving, to whom the property you're being, to whom the property is being distributed to, and what will be the consequences if I give this particular property to them. Only if that person can understand all these three things is when you are this you mean to be a sound mind person. And also there are certain 4 explanations which are set down under section 59. Explanation 1. A married woman may dispose by will of any property which she could alienate by her own act during her life, which is very simple. I'm a woman. I own A, B, C, D property. So if I'm aiming A, B, C, D property, as a woman, I have the right only to dispose of only these A, B, C, D property. This is what explanation 1 means. Explanation 2. Persons who are deaf or dumb or blind are not thereby incapacitated for making a will if they are able to know what they do by it. Which means to say, a person who is deaf or dumb can also make a will, provided they understand what they're doing. Only when they understand the repercussion consequences of what they're doing, the wills are valid even by persons who are dumb or deaf or blind. That is explanation 2. Explanation 3. A person who is ordinarily insane may make a will during interval in which he is of sound mind. As I said, if a person who is at interval times he is of sound mind, and at some other intervals he is of not sound mind, so a person who is making the will when he is of sound mind also will be a valid will. Explanation 4. No person can make a will while he is such a state of mind, whether arising from intoxication or from illness or from any other cause that he does not know what he is doing. So let's say there are two conditions here. I am now completely intoxicated. I am under this influence of drugs. I do not understand. I am in a state of hallucination. I do not understand what I'm doing is right or wrong because I'm in a state of intoxication. I do not know what is right. So when I make will at that particular point of time, then it cannot be said to be a valid will. Let's say, suppose I am on my deathbed. I do not understand. I am on a ventilator. I am having more than food. I am having, the glucose has been put to me. I've been injected with injections and stuff like that. I'm literally on a deathbed. Can a person on a deathbed make a will? No, he cannot. He should understand the repercussion consequences of making a will. So this is when it comes to who all can make a will. But the law is not stringent with respect to the. Now my next direction will go to a flow which says, okay, now I've said such and such person can make a will, what amounts to a will, but is there any particular format to make a will? Do you have, see, if you are a student, you might know that you should first have introduction, and then you should have a body, and then you should have a conclusion. You should have this proper set of flow in your answer sheet is what generally your professors will actually guide you. But when it comes to a will, do you have any such particular format which you have to undergo, or you have any stringent format for you to execute that will? No, the Indian Succession Act does not give you any stringent or exactly the format of the will, but there are certain essential requirements to be fulfilled in order to make your will valid. Firstly, Section 63 states the requirements of making a will. Execution of unprivileged will. So what does it say? Firstly, the testator shall sign or affix his mark to the will. So I just like that cannot write a will without signing. Whatever you're writing, you have to sign it. You, as in the testator who's making the will should sign the will. Only when you sign the will is a valid will. But on your direction, the other person on behalf of you also can sign or mark his or affix his mark on the will. This is the first important requirement. Second is very, very important in order to validate your unprivileged will. That it is to be attested by the attesting witnesses. What do you mean by attestation? So attestation of will is nothing but means signing a document for the purpose of testifying the signature of the executants. Therefore, an attesting witness signing before the executant has to put his mark on the will cannot be said to be a valid attestation. It is nothing but you make a will, then two other persons has to sign on the will apart from the testator's signature. Let's say I am drafting a will, I being the testator, I sign. Then I tell A person and B person who are not the beneficiaries of the will. I say A person and B person, come also see I have drafted this will, sign it on behalf of sign it to make this as a valid will. So A and B person are the attesting witnesses to my will. Now that I've said two or more attesting witnesses have to sign for this will, so now the question should be, are these two attesting witnesses to sign the will at the same time? Should, now that I am the testator, I tell both the persons, come on, at 6 o'clock, you have to be in my house, sign the will at 6 p.m., both of you. I cannot give such conditions. Both attesting witnesses can sign the will at two different times. Even that also amounts to a valid will. Thirdly, Section 74 states that no technical words or terms can be used in a will. What happens in the drafting is, or when you are a good drafting, when you have such good drafting or vocabulary, you need not make it very fancy. You need not make the will look very fancy. You can use normal terms like normal English, you can use it, so that the only main intention or the conclusion is that the person should understand what your wishes are. The person should understand what your intention is. Just because you use some fancy xyz words, and if that goes beyond your understanding, that does not give any validity to the will which you make. So that's when you make your will a little less technical by using less fancy words and within ordinary terms and words and language. Next, I make a will. What if I don't describe the properties? So the property, be it movable, be it immovable property, it has to be mentioned with proper description. Let's say you are selling some particular site number 37. Just because you've written I am giving site number 37 to my daughter, is it a will? What site number 37? There are so many site number 37 in so many areas, in so many districts, in so many states out there. So you have to mention site number so and so in village so and so, which belongs in so and so district of so and so state. And you have to, for even more giving detailing of the property, north, east, west, all the boundaries have to be set by. So that is called the detailing of the property. When it comes to immovable property also, the shares what you take, the bank account, everything has to be mentioned specifically. Just because you tell that I have 9 accounts, so all those 9 accounts I wish to give it to my daughter or my son or to XYZ person, that is an amount. Which bank? If you do not specify which bank, how will they understand that in which bank does that person has that particular immovable property? So the specification, if you're giving up any account in favor, then the bank accounts has to be filled up. If you're giving any shares, the share detail has to be has to be dealt under that will. So these are the specifications or detailing of the property. Next, the description of the beneficiary has to be also mentioned. Let's say you write everything, you write detailing, you give the detailing, what properties, everything you write down. But to whom? Just you write Aishwarya, I'm giving this property to Aishwarya. There are millions and lakhs of Aishwaryas out there. Which Aishwarya? So you have to mention Aishwarya as Hanchate, daughter of so and so, belonging at so and so place and time. So the specification of the beneficiary has to be met out properly in order to make the will valid. Now, these are all the requirements which you have to keep in mind if you have to make a will valid, to validate your will. These are the common requirements which has been stated under section 6374 of your Indian Succession Act. Now, next comes, should this will be registered? Is it a compulsory registrable document? Now, where do you see whether that document is a compulsory registered or not? So, the Registration Act 1908 talks about which documents are compulsory registrable and which documents are not. So, Section 17 talks about which documents are to be compulsorily registered. But Section 18 of the Registration Act specifically states that the will need not be compulsory registered. But as a matter of caution, most of the times the will is also registered so that there is no such there is no ambiguity in near future. Just to make it more safer side, people do register, but according to law, will is not a registrable document. Next, there are certain important criteria also to be dealt under the topic will. Now that I am left with 15 minutes, I'll just take 10 minutes so that 5 minutes are reserved for your question and answers. Next, what happens if a person, let's take, I am in a dominant position. I say, look, you are under me. I'm in a dominant position. I say, you have to do such and such property to some other person under undue influence. Can that will which is made under undue influence be deemed to be valid? No, it cannot be. Same in the case of fraud. When it comes to misrepresentation, be it fraud, when I say I conceal certain facts, and under those concealment of facts a will has been drafted, can that will be deemed to be valid will? No, it is a void. It is deemed to be a void will. What happens when I say I'm in a state of hanging myself and I tell I'm hanging myself, I will hang myself to death if you do not give such and such property to me under that will. If I, under that coercion, if I say that person to make a will, can that will be valid? No, it's the void will. Next. So these are the under section 61 of Indian Succession Act. It states that the wills are the wills due to fraud, coercion, or undue influence will be void. And next, section 89 is also one such important provision. What if the will is down with uncertainty? There are no such certainties in the will, be it in terms of boundaries, be it in terms of specification, be it in terms of maybe you have not signed, or maybe you have not set down the proper clauses. So in terms when there are such uncertainty, then the will be deemed to be void. It is a void will. So these are the conditions where your will are deemed to be void. Now, there are important case laws which have to be discussed. When it comes to will, the very, very important law which has been set down by the Honorable Supreme Court when it comes to the will and the proof is H. Venkatachala Iyengar versus B.N. Timmajamma, 1951, Supplementary 1, SCR 426, or equivalent citation AIR 1959, SC 443. This particular judgment sets down how to prove a will. What if a will is being bought? How do you prove the will? This particular judgment sets out the answer for all such questions, and this is one of the landmark judgment when it comes to will. I will just read out certain portions of it. So the judgment which has been set down, it actually questions itself and then it answers. So what is it? What is the true legal position in the matter of proof of wills? Is it well known that the proof of wills presents a recurring topic for decision in courts, and there are a large number of judicial pronouncements on the subject? So it really asks the questions to itself as to what is the legal position in the matter of proof of wills. How do you prove the will? So they come down to section 67 and 68 of the Evidence Act, which are relevant for this purposes. So under section 67, if a document is alleged to be signed by any person, the signature of the said person must be proved to be in his handwriting, and for proving such a handwriting under section 45 and 47. So 45 and 47 of the Indian Evidence Act gives the provision for the opinion of the experts in order to validate the handwriting of that person. And section 68 deals with the proof of execution of the document required by law to be attested, which is very, very important. This talks about the attesting witnesses. It provides that such a document shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. So, as I said, propounder signs, and then there are two or more attesting witnesses to that will. So, when at the time of execution, the court has to be satisfied. It can be taken into evidence only when the attesting witnesses, are called for proving the will. So, one attesting witnesses at least should come and prove the will. And also section 59 and section 63 of the Indian Succession Act are also relevant to this aspect. As I said, section 59 talks about the will should be drafted, the will can be made by the sound mind person and not by minor. So that is section 59. And section 63, that the testator signature and two or more attesting witnesses, all those are the points which have been mentioned. So you can actually go through this judgment. And Venkatachala Iyengar versus B.N. Timmajamma, which is one of the landmark judgments when it comes with respect to the proving of wills. Second, I have taken out a very recent judgment of this is authored by Justice Sanjay Karol in the Honorable Supreme Court of India. In this judgment, having referring to the previous judgment, that is Timmajamma judgment, and also referring to other important judgments, have also laid down the principles required to validate an execution of the will. So they have given certain pointers. So firstly, that the will has to be executed by the testator, and secondly, it should be the last will executed by him. As I said, a will can be written down as many times during his lifetime. So only the last will has to be executed. Secondly, it is not required to be proved with mathematical accuracy. Only the test of satisfaction of prudent mind has to be applied. The court has to get satisfied that yes, this is the will which is written by the testator, and this is his intentions, and this is what he desires to give it. So that satisfaction has to be taken effect to. Then It has to be fulfilled by the formalities required under Section 63 of the Succession Act, which means to say that the testator has to sign or affix his mark, and mandatorily 2 or more attesting witnesses have to attest that will. And each attesting witnesses, another point which I missed out earlier, is that the attesting witnesses must have seen the testator sign or affix his mark to the will. So the attesting witnesses should not only sign, he also have to see whether the testator has signed or not. So while the testator is signing, the attesting witnesses also have to see it. Then each of the attesting witnesses shall sign the will in the presence of testator. However, the presence of all witnesses at the same time is not required. So as I said, when there are 2 or more attesting witnesses, they need not come at the same time and sign, but they have to sign in presence of the testator. Because what if I am on the deathbed and I can't and I've written the will, I have just signed it and kept it somewhere, and attesting witnesses after, when I am on deathbed, sign it on the will, that doesn't make it valid. So in order to make it valid, I should be present. In my presence, the attesting witnesses have to sign the will. So for the next point, for the purpose of proving the execution of the will, at least one attesting witnesses who is alive, subject to the process of court and capable of giving evidence shall be examined. So as a matter of course, one of the attesting witness shall be called upon in the court, and he'll be called on the witness box, and he has to validate whether he has seen the testator signed it, whether he has signed it, whether the clauses have you seen if that person. So these are all the questions and practicality which goes on in the court of law. Then the next one, the attesting witness should speak not only about the testator signatures, but also that each of the witnesses has signed the will in the presence of the testator. Then if one attesting witness can prove the execution of the will, the examination of other attesting witness can be dispensed with. So it's on the discretion. If there are 2 or 3 attesting witnesses, and if one witness comes and satisfies the court that yes, this is the will which has been executed by the testator, then it is on the discretion whether or not to call the other 2 attesting witnesses. Suppose if the next point, what it says is, suppose if I fail to prove that whether the testator has written down that will, or if I have if there is certain doubts in the minds of the court, then the other attesting witnesses may be called. It is on the discretion of the court. And another very important major topic which is discussed under the wills are whether the will is made under suspicious circumstances or not. So there are plethora of judgments by the Honorable Supreme Court and various other high courts which has dealt with what amounts to suspicious circumstances, what not amounts to suspicious circumstances, what is suspicious circumstances, the definition of suspicious circumstances are all elaborated time and again being discussed by the Honorable Supreme Court. So if there rises any suspicious circumstances, then the propounder of the will, who is the propounder of the will? When I am realizing that I am taking the will before the court, when I am presenting the will, I become the propounder. So if there is any suspicious circumstances surrounding the will, then I have to make sure that all the suspicious circumstances which has been born in the mind be eliminated or discarded. So I have to eliminate all the suspicious circumstances surrounding in and around the will. Let's take what might be the suspicious circumstances. Let's say that the will has not been created by the testator. The will is a created document. The will is let's say is created, the signatures, the testator's signature is not the testator's signature. So all these suspicious circumstances have to be proved by the person who by the propounder of the will. So I have to remove all these suspicious circumstances, but provided now recently there is a judgment which says that if a person who's stating that the will is who is bought by undue influence or by coercion, then it is on that person who is asserting it. So the the amount of proof of such undue influence or coercion has to be by the person who's coming forth with such circumstances. Then next, and very and something which the Supreme Court has summarized in this judgment, Meena Pradhan and others versus Kamla Pradhan and another by the Honorable Supreme Court of India, which is by Justice Sanjay Karol. The justice has also said that apart from statutory compliance, it has to be proved firstly that the testator signed the will out of his own free will. As I said, I should not be coerced by somebody else. I should not be forced to make this will. That's when it becomes a valid will. Secondly, that at the time of execution, it should be of sound mind. I think I've predominantly taken a lot of time to explain you the sound state of mind. Thirdly, he was aware of the nature and effect thereof. I should know what I'm doing. I should know what are the consequences vest upon while I'm doing this. And the will was not executed under any suspicious circumstances. As I've explained, what amounts to suspicious circumstances. And yes, there are many plethora of judgments which talks about what are the suspicious circumstances. Then our own Honorable High Court of Karnataka, which is authored by Justice N. Kumar, and in the judgment, Parappa and others versus the citation follows. ILR 2008, KAR 1840. So this is another judgment. In fact, Justice N. Kumar has elaborately dealt with and discussed a lot about the laws governing the will. But I have picked one judgment of Honorable Justice N. Kumar in the above said judgment. What if now I said that there should be two or more attesting witnesses? One of the attesting witnesses have to come forward in order to prove the execution of the will. What if both the attesting witnesses have dead? So does that mean that will doesn't come into picture? Or does it mean that okay, now there is nothing doing with the will which has been written by the testator? No, the law also gives, and also Justice N. Kumar has also elaborately dealt with this point. I read it as follow, I quote and unquote. Section 67 does not prescribe any particular mode of proof. In addition to usual modes, handwriting may also be proved by circumstantial evidence. Therefore, it necessarily follows that if the attesting witness are not alive, if the attesting witnesses are not alive, persons who are well acquainted with the handwriting or signature of the attesting witness should be examined to prove the signature of the attesting witness. When the handwriting of a dead attesting witness have been proved, there is assumption of that they have witnessed the execution, which means to say when two attesting witnesses have died, then any person who is well acquainted with the handwriting of these attesting witnesses, if they prove that this is the handwriting of such attesting witnesses, then the then they have witnessed that execution of the will. So this is one judgment when it comes to the question, what if both the attesting witnesses have died? Then this judgment can come to a rescue or answer your question. The next judgment is uh, by the Honorable High Court of Delhi in the case Vikrant Kapila and others versus Pankaja Panda and others. So in this judgment, they have dealt with, suppose there are many clauses in the will, and what if the clauses are conflicting with each other? How to give effect to what has to be done when the clauses are in conflict with each other? Then they have elaborately dealt with. It has stated that the will has to be read in whole, and if there are any inconsistencies or if there is any contradictions to the will, then something which uh, overrides all the confusions, then that particular interpretation has to come into picture. Then all clauses in a will are to be given equal importance. If there are A, B, C, D clauses, there are like at least 5, 6 clauses in one picture, and if you say that no, only let's give importance only to one clauses, only to second clause, no, that's not the law. It has made it very clear that all the clauses have to be given equal importance, and there should be uniformity in reading the will. And suppose if the clauses are inconsistent and if they have divergent meaning, then the more meaningful clause, the one which clears of the confusion, the one which is more powerful, the one which gives you clear picture about what that clauses mean, then that more meaningful clause has to be given when compared to the less meaningful clause. These are the pointers which have been set down by the Honorable High Court of Delhi in the case Vikrant Kapila and others versus Pankaja Panda and others. Another very important question, another very important note, which will be my last point of discussion here with this judgment. In the the Supreme Court, in the case Varnalata and others versus Kalavati and others, they have dealt with very interesting question. Uh, what if I have 5 children? Let's take, I have 4 children, and I have written a will only to one child out of my 4 children. So, can this will be surrounded with suspicious circumstances? Can this will be invalidated? It is the will and wish of the testator. He has given all his entire property to one particular daughter and not to the other 3 children. So, can you deem this will to be invalid? No, you cannot. So, this Honorable Supreme Court has come to this conclusion that the exclusion of one of the natural hires from the bequest cannot by itself be a ground to hold that there are suspicious circumstances. So, just because you exclude one of the legal heir, when you have as an example, when I gave you, when you have 4 children and when you have excluded 3 and have given away all the property to one of your kid, can that be surrounded with suspicious circumstances and tell that no, this will is not a valid will? No, you can't. So even after exclusion of your legal heirs, you can validate that will, is the answer given by this Honorable Supreme Court. So with this, again, I say that there are plethora of cases which deals with laws, and I have picked few in order to give clarity to my session. If there are any doubts, and if I am competent enough to answer your doubts, I'll be happy. Okay, so there are some questions which are here. I will just, can you please give a background for testamentary? In which context? I think I've pretty much explained you on the background of testamentary will, like the difference between intestate succession and the testamentary succession. So the entire session, because it was on testamentary will, I hope this question gives you the clarity. Then I have 2 questions. Okay. If a property inherited by sister. Okay, so here's a question. If a property inherited by 5 brothers and one sister after the demise of their parents, and if the sister who is a divorcee is not in contact of any of the family members and distant relatives since past more than 10 years, ever since the death of parents, how the property can be disposed of without the sister's concurrence? Look, as a matter of right here, the sister is also entitled to the property. Now that here there's no clarity as to whether the parents have written the will or not, so it comes under the intestate succession. So the property has to get devolved with respect to the if they are Hindu, then it will get devolved in terms of Hindu Succession Act. Class 1 and class 2 legal heirs will follow. So I hope I answered to this question. My eldest and youngest brother since more than 10 years.
अगर आप माइक ओपन करके क्वेश्चंस पूछना चाहते हैं तो पूछ सकते, कोई इशू नहीं।
हाँ जी, मेरा 2 क्वेश्चन है।
Yes, sir, please.
Ma'am, that question 2 is still unresponsive by you, ma'am, which you are reading right now.
Yeah,
In fact, I have asked that question. That is the reason I thought I'll just
yeah.
seek
Can you
reply
please,
from you.
1 second? I'll just go moment with the reading the question. If there is same property, if there is same property is occupied by eldest and youngest brothers since more than 10 years after demise of parents, and two brothers out of balance, three brothers undertakes the construction and first floor for their respective purpose of residing out of their own expenses. And the brothers were during the documentation of regularization of additional construction carried out at the property one of the brother earlier have no interest in. I think this is out of scope of the topic for today, but otherwise, if I do not know, there are certain ambiguities in the question. I do not know if on what property are they building, what approval are they taking. So, because there is an ambiguity in the question, I do not want to give any such wrong answer for this question.
Right, ma'am. ठीक है.
Yeah. So next question is, if I'm replacing a will by gift deed, will has to be cancelled first. See, replacing a will by a gift deed. As I said, the effect of these two deeds. What effect do these two deeds come into picture? One, if you make a gift deed, then there is an immediate transfer. But when you make a will, the transfer is after the death of the person. So when the effect is as such, when you make a gift deed to some person, then the entire property will immediately get transferred to that person. And now that the will can be revoked expressly or by impliedly, there is a provision under the Indian Evidence Act that the on the revocation of the wills, if you give me a moment, uh, yeah. So section 70 deals with the revocation of unprivileged will or codicil. No unprivileged will or codicil nor any part thereof shall be revoked otherwise than by marriage or by another will or codicil or by some writing declaring an intention to revoke the same and executed in the manner in which an unprivileged will is here and before required to be executed, or by burning, tearing, or otherwise destroying the same. So when you're making a gift deed, which means that you're implying that you're revoking that will and you're immediately transferring that property by way of gift deed. So necessarily it amounts to implied revocation of the will is my answer. I hope this is satisfied by you by my answer.
Ma'am.
A person
Can I,
on yes,
can I
please.
ask?
Yeah.
Yeah. Can we just write in the will total immovable and movable properties? Because I keep on buying shares and sometimes I invest in properties, sometimes I come out of the properties. Can we write total immovable and movable properties to my son?
No, in that case, it amounts to uncertainty, right? So now that you just say total movable and immovable property, what do you amount by total immovable and movable property? So
At
now,
last at the end, what is remaining, it all belongs to my one son only.
but what if you have your ancestral property also, you have your self-acquired property also, you also do not know that what are the properties. Let's say for example, I say I have without giving any description of the property, I say all my immobile properties and all my movable properties are transferred to my daughter, is exactly precisely what your question is. Now, how do anybody get to know that what are all your movable and immovable properties?
That
How
will
should
be
one
as
get
per the
to
IT returns. That the income tax return and the registered deed will tell, no?
no? Why are you giving the scope of the uncertainty around the will? Make it certain. Make it, because once your will is
Maybe today I have
uncertain,
these
that day you should be
shares,
a void
tomorrow
will.
I don't have the shares. I'm holding shares of Reliance. Maybe today I have, tomorrow I don't have. Again, I keep on buying, switch on.
Yeah, you also have the provision of making your will time and again during your lifetime. So
No,
you can make your will time and again during your lifetime, make it certain. So once your will is not certain, the will is deemed to be void. So you just cannot execute a void will, is my answer. I hope it has satisfied you.
sure. Thank you.
Yeah, welcome.
Ma'am, ma'am, one question.
Yes.
Hello. Yeah. Am I audible, ma'am? Hello.
Yes, Yogesh, Mr. Yogesh.
Good evening. Good evening, ma'am.
Yes.
Ma'am, my question is, this pertains to specifically to the metro cities, wherein all the buildings are in a form of a cooperative housing society. Uh, Most of the places, in absence of any will, can the form of nomination, which encompasses all the structure of a valid will, be treated as a will in absence of the actual will?
Yogesh, I'm so sorry, your voice is a little breaking. Can you please repeat for me?
Ma'am, hello.
Yes, Yogesh.
Yeah. Uh, in cooperative housing societies, uh, we have this form of nomination. So, in case of any expressed will, can this form of nomination be treated as will? As this form of nomination, the language used and the way they are executed satisfy all the conditions of valid will, including non-intervivosity, be it the ownership, because the ownership is already proved by virtue of a share certificate, and that share certificate is already uh, embedded as a part of the form of nomination. So my question boils down to this: in absence of for a given situation, in absence of in any expressed will, can this form of nomination, which encompasses all the essentials of valid will, be treated as will?
Like, what nomination are you talking about, Yogesh?
In normally in metro cities or in any cooperative housing societies, because cooperative housing society act itself is a act in
Okay,
itself.
but now are you the owner of that particular property? You have written, you have satisfied all, but another essential condition is, are you the owner of that property?
Yes, I'm saying all the valid conditions to satisfy a will. That is first number thing, the self-occupied, the self-owned, all the self-owned property. Number two, the document is executed at the time wherein person is mentally and legally fit. Then the valid attestation by two people, and the document expressly mentioned that it needs to be given effect after my death. That is the intervivosity. So
Yeah.
all the valid essentials of a valid will are satisfied, but it only mentions that this is for the purpose of nomination. Here, mostly what happens, the language used in such nomination forms is such that the person who is writing the form of nomination feels that this is a will. I don't have to prepare a will, because the language is expressly mentioned that after my death, the shares mentioned in the said property should get transferred to so and so person, and the interest in the flat. So the word and interest in the flat, because the first part is talking about the transfer of share and another part is talking about the interest in the flat. So can this be treated as a valid will?
Yogesh ji, you should also make note, in order to make your will valid, there is also another condition that you should be the owner of that particular property. Only when you're the owner of that particular property is
That
also
is
another
already
valid
that is
condition.
that is already a precondition to sign that form. Only the person who is a valid owner of the property can only can initiate such form.
Yogesh ji, I'll have to look into it clearly in order to answer your question. So I have to get back to this question, Yogesh ji.
Okay, man. Good day. Good day.
Yeah, okay. Thank you.
Madam, I have two questions.
Yes, sir, please.
Okay, first question is that when there are matrimonial disputes going on, we
Hmm.
cannot predict what will be the results of the matrimonial cases. So as
Yes.
such, we cannot decide whom to give the properties and all. So in such cases, how to draft a will?
See,
What are the precautions to be taken?
See, when your matrimonial case is pending, not pending, that is the dispute which is happening between two parties, that is the husband and the wife. But in this matrimonial dispute, it is nowhere stopping you from thinking as to what you're supposed to do with respect to your properties. Right, it is the fight, legal battle which is happening between between the husband and the wife. So suppose if the husband has the right to deal anything with respect to his property. See, where the as soon as the petition is filed, it nowhere bars that person from doing anything with respect to his property. So he can actually he can safeguard his property. So that is, legal proceedings cannot bar him from executing a will.
No, but my question is, we cannot take a proper decision when matrimonial cases are going on, because if everything is normal, all the properties will go to the wife and children. But here there is a fight going on, so we cannot make proper decision as to whom we have to transfer the properties after our death and all, or especially in case of sudden deaths actually.
See, what happens when the property has to develop on the wife and children, it's all when it comes to interstate succession. But when it comes to will, as I said again, you are freed. You you can actually decide as to what you're supposed to do with your property. You can give it away to your children completely. You cannot give it by excluding your wife. You can do anything with respect to your property, because entirely ultimately you are the owner to that property, right?
Okay. And my second question is like, can I make some conditions when I'm drafting the will, like after my
Yeah.
death, conditions like after my death, so and so property should be enjoyed by so and so person, and after the death of that person, that property should go to some ashram and some mutt, like that. Actually, can I make some conditions like that in my will?
Conditional will is valid only to some extent, sir. So when it comes to, like, say, let's say, suppose I want to make a will to someone who is an unborn person. So I just like that, I cannot say so and so particular property will vest to my grandson or my granddaughter. That cannot be made valid only after me creating a life interest to somebody, and thereafter when they attain a particular age, that's when this will becomes valid. Well, let me make it more clear. Only when I make a life interest to one person and then I am ultimately giving the property to some unborn person, then yes, that will may be valid, can be valid. And even conditional wills also are valid to some extent with proper requisite valid conditions.
Okay, madam. Thank
Yeah.
you.
Yeah.
Nice attempt. Okay. Thank you.
Madam, I have a question.
Yes.
Uh, while making a will, the Christian family, can the ancestral property be willed away by any person? Christian family, not an HUF. So, can the ancestral property be willed away by a son or daughter? That is my question, madam.
I am sorry, sir, but there are two heavy terms, that is Christian and ancestral property. If you can give me
Right.
clarity as to these two.
Okay. For example, ancestral property by the grandfather.
Okay.
Can the daughter
Sir?
will away the property?
I couldn't hear you because your voice just broke down.
Yeah, yeah. Can the daughter who has other sisters will away the property of her father, that is my grandfather? Can it be done? Because it is ancestral property, say. That
No.
is belongs to the grandfather.
Yeah, as I said, when you are a co-partner, when you being a co-partner, when there is an ancestral property or when there is a joint family property, you cannot give away that property by making a will. When you are co-partner,
Right.
when your other co-partners have interest in that ancestral property, you
Yeah,
cannot give away by making the will.
yeah. But this is not a HUF. This is supposing it's a Christian family. Then the question of co-paternity does not arise in Christian family.
So when it comes to Christian, I think there is a recent judgment which says that Christians, there is a particular judgment, sir, which has been recently taken by the Honorable Supreme Court.
Right.
that has talked about that has brought amendment to a section, sir. I'll have to go through. I've just recently read, which I'm
No
not able
problem.
to
Sorry.
recall. But you can actually Google, you can actually research, which has recently brought the amendment to in the year 2002 or 3, if I'm not wrong. In 2002 or
Right.
3, there is an amendment brought with an effect to the Christians. So I
Yeah.
think you can devolve upon that research, you might get the answer to this.
Okay. Okay. Okay.
Yeah.
Thank you, madam.
Yeah. Thank you. So I hope my
Can
webinar.
I ask one question, please?
Yeah. Sure.
Yeah.
Suppose I make a will in name of wife, and after my wife, that my two children should be the beneficiary. Can I write the name in the will of the two beneficiaries also, my son and daughter?
Yeah, definitely. You are making it, you're giving a life interest to your wife, and thereupon you're laying this condition that thereafter the property will be dealt upon to the children. Definitely, that can be a valid will. So,
So
this.
the question arises: will my wife have to make a will again because she has inherited from me?
No, see, creating a
Can
life.
she change the other person? Can
No,
she?
see, ultimate beneficiary you have written down in the will. It's just that your wife possesses a life interest. So ultimately, the ultimate beneficiary is your children. So by that way, your wife cannot actually deal or alter anything with respect to that particular property.
And suppose if she wants to sell that property,
Then the consent, if suppose if the ultimate beneficiaries have come down to a major, so the consent of the major also have to be taken into consideration, provided that in future they are going to be the ultimate beneficiary of that property.
okay, thank you.
Okay. So I hope everybody actually did. Um, I hope this was a fruitful session from my end, and I made sure that the session goes in a very simple language, provided there was a mixed audience from students who are from initial days in their law school. So if there was any unambiguity, I apologize if I couldn't answer to your queries. I'll make sure that I go back, I read, and then with some other mode of communication, I will communicate the answer to you. And I hope this session was fruitful. Akshay, is this okay? Akshay?
Yes, ma'am. Yes, ma'am.
Yeah.
Yeah. Thank you so much, ma'am, attending this webinar.
Yeah.
And uh, I extend my grateful gratitude to each of you are active participant to today's webinar. Your insightful questions and engagement have is made the event truly engaging, enriching. Special thanks to our estimate speaker for sharing their expertise. Let's continue to learn and collaborate in this future later. And thank you so much, ma'am, for attending this webinar.
Thank you so much. Thank you. Namaste, everybody.